Welcome back again. We're still on the topic of complex litigation. This is likely not the last civil procedure episode, but we're getting pretty close. There's only a couple more things for us to talk about. Today we are talking about third-party claims, and this is called an impleader under Rule 14. Rule 14A1 says a defending party, that means a defendant, may, as a third-party plaintiff, serve a summons and complaint upon a non-party who is or may be liable for all or part of the claims against it. Okay, so let's break this down. Plaintiff sues defendant. Plaintiff does not sue all the potential defendants. Defendant realizes there are other potential defendants out there who may be liable to the plaintiff for this accident or for this claim. And so the defendant says, I'm going to sue them to gather in my losses. And so this introduces the concept of indemnification and contribution. So indemnification is to compensate the defendant, or in other words, to reimburse them for their loss. And this arises out of contract law. Contribution is when somebody contributes in part or in full, and as a result, the defendant is reimbursed to the amount of the contributor's responsibility or their liability. And this is related to tort law. So, for example, when it comes to indemnification, say this is a breach of contract. The plaintiff sues the defendant. The defendant says, I was not in breach with this contract, but this party was in breach of the contract. So we are going to bring them in to reimburse us for any judgment that comes against us. Contribution is the other party contributed to your injury in tort, and as a result, we want to be reimbursed for any part that we did not have. Rule 14 allows these complaints to be heard by the same jury, and again, the whole purpose of this is to avoid additional litigation and to minimize court expenses and court time. It is important to note that this is not a cross-claim. A cross-claim is where... Actually, I'm not 100%... cross-claim. I feel like that's similar to a counterclaim. Maybe not, though. Ignore that. It's just not a cross-claim. That's what we need to know as far as Rule 14 goes. The other big main takeaway from this is that this is derivative liability. Derivative liability means that one party's liability occurs because of somebody else's liability. If a person is solely liable to the plaintiff and not the defendant, then Rule 14 can't apply. So let's break that down one more time. Plaintiff sues defendant, and the defendant is liable to the plaintiff. However, the defendant is liable to the plaintiff because somebody else is liable to the defendant. A good example of this would be Walmart. The plaintiff buys a toaster from Walmart. Walmart sells the toaster to the plaintiff, and the plaintiff ends up getting hurt or burnt because the toaster was defective. The plaintiff goes ahead and sues Walmart. Well, Walmart knows that somebody else made the toaster, and that person who made the toaster would then be liable to Walmart because they did not provide Walmart with a good toaster. So Walmart is still liable for selling the toaster, but the other party would still be liable for giving the toaster to Walmart to sell. So, how's that going to work? Plaintiff sues Walmart. Walmart adds in this third-party defendant as a third-party plaintiff to be compensated because of their contribution to the injury. And there's a whole lot of strategy that comes into this too. Sometimes plaintiffs are going to choose not to add in additional defendants. And there are two main reasons for this. Sometimes the plaintiff doesn't know that there would be additional defendants to add in. For example, a toaster has several parts. They may not know who manufactures all the parts of the toaster. As a result, it's just easier for them to sue Walmart. And the second reason is for strategy. A lot of the time, small local businesses have very close relationships with suppliers. And so in order to add a bit of pressure onto these small local businesses, a person who was injured would hold off on suing any potential additional defendants because they want the defendant to bring them in themselves. And this may, put a hard situation on the defendant because they are suing that supplier. And if that defendant wants to maintain close relationships with their supplier, they want to hold off as long as possible before bringing them in. So we have two cases related to this. The first is Erkins versus Case Power and Equipment Co. There's not too much to talk about it. I just want to say that this case is a good example of an impleader rule. I won't get into the facts, but that's pretty much all we need to know about that case. It is important to note, too, that subject matter jurisdiction must still apply when you bring in a third-party defendant. And this is a good example from Owen Equipment and Erection Co. versus Kroger. I will talk about this case because it's pretty interesting. Ultimately, what happened is so the plaintiff was an Iowa resident. The original defendant was a Nebraska resident. And then the defendant brought in a third-party defendant who they believed originally was a Nebraska resident, but turned out to be an Iowa resident. So ultimately what happened at that point is that the Iowa plaintiff ended up suing the third-party defendant because that can happen. And then the original defendant dropped out of the case, and so now you're left with Iowa suing Iowa. And turns out, what do you know, this was all happening in a federal court. And as we know from subject matter jurisdiction from last semester, an Iowa defendant cannot be sued by an Iowa plaintiff for state law claims unless if it's coming in through supplemental jurisdiction. But in this case, there was no anchor claim, and as a result, it ultimately does not work. So we're given a couple of hypotheticals. We'll say that that is the first hypothetical. The plaintiff is from Iowa. The defendant is from Nebraska. It's a state law claim. In that instance, the plaintiff may not bring another defendant from Iowa through Rule 14. A couple of other examples. We'll say the plaintiff is from Iowa. The defendant is from Iowa. This is a federal claim. In this instance, the defendant may bring another person from Iowa through Rule 14, applying supplemental jurisdiction if that additional claim is a state law claim. A third hypothetical is, imagine the plaintiff is from Iowa. The defendant is from Wisconsin. This is a state law claim. The defendant may bring another defendant from Wisconsin through Rule 14, applying again supplemental jurisdiction. So you can see domicile still matters in these situations. We need to make sure that we check the boxes. The rule is met and the subject matter jurisdiction is also met. So big takeaway from this portion is that defendants may use the plaintiff's anchor to bring in a third-party defendant, but that option is not available to the plaintiff. That's civil procedure. That's third-party claims. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice. And with that, the fourth thing is if it is used as legal advice, we are not liable. That is, law scholars is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.